good afternoon, and thank you for your kind introduction, and thank you for keeping up on Saturday afternoon for the penultimate lecture. So the last two lectures will be dealing with family from different perspectives. One will be from social security law, more or less, and the other one from civil law, if I'm not mistaken. So my intention is to present briefly a chapter of the book we were preparing, but also broaden it a bit and speak about family protection in cross-border cases in the European Union, which might be even more interesting for you as cross-border students, or at least those who are cross-border. So the title is Family Support through Social Rights. Now, the first thing is about different generations of human rights. We always say that human rights should be indivisible, so they're universal. Every human should have all human rights, and they're interrelated. Especially social rights are very much interrelated. One is dependent on the other. The right to health, if you don't have health, then you can hardly exercise any other right, like to education, to vote, and so on. And so human rights are interrelated. And then that is visible also in the United Nations. Everybody knows the Universal Declaration of Human Rights, where you have all human rights in one document. But if you look closer, you still have a distinction within the Universal Declaration of Human Rights. Like in first two articles, you have, the emanation of French Revolution, like everybody is born equal, equality, so liberté, égalité, fraternité, so everybody is born free and equal and should act towards each other in the spirit of brotherhood. Okay, that's basically solidarity, because today we should say sisterhood or siblinghood, it's solidarity. And then Article 3 is an introductory article to civil and political rights, and then we have Article 22, which is umbrella article for social, economic, and cultural rights. So within the declaration, that is my point, you still have a differentiation between different kinds of human rights. Human dignity and human personality and development of personality should be in Article 3, so like an umbrella article for all human rights, but it's now in Article 22, so we have a division. And that division is seen also with the International Covenant. We have two. One is on civil and political rights, and the other is on economic, social, and cultural rights from 1966. Then within the Council of Europe, everybody was discussing the Convention for the Protection of Human Rights and Fundamental Freedoms, which is European Convention of Human Rights. But don't be misled by the title, because European Convention of Human Rights does not entail all human rights. You cannot find social rights in the European Convention of Human Rights. Okay? That's why we have European Social Charter. And we have different kinds of rights and different supervisory bodies. We have European Court of Human Rights supervising the European Convention of Human Rights, and we have European Committee of Social Rights supervising the European Social Charter, which of that committee I am currently a member as well, so it's international human rights supervisory body. What is also interesting, if you look at the statute of the Council of Europe, I think in Article 5 it says, in order to be a member of the Council of Europe, a member state should respect human rights. It says nothing about the European Convention of Human Rights. So my argument would be, if we mean seriously with indivisibility of human rights, that all member states should ratify not only the European Convention of Human Rights, but also the European Social Charter. The first one from 61 or the revised one from 96, which is not the case. We have 4 countries that have not ratified the European Social Charter. There are 3 smaller ones, Liechtenstein, San Marino, and Monaco. It's okay, they don't have their own social rights or social security rights, but also Switzerland. Okay? And unfortunately or fortunately, current Secretary General of the Council of Europe is Swiss, so don't expect Switzerland to go, or the Council of Europe at the moment, to go for such an extensive interpretation. But it would be correct, in my opinion. So in the European Union, we have Charter of Fundamental Rights of the European Union, which is good because we have all human rights or all rights of the European Union in one charter, but it does not add anything to European Union law or add nothing to national law, because it does not give any new competencies to the European Union or any new competencies to the member states. Nevertheless, the Court of Justice of the European Union referred to the Charter of Fundamental Rights of the European Union in many cases, in more and more cases, also some relating to cross-border healthcare, to family rights as well, the right to dignity, and so on. Now, there is a challenge of definitions if you speak about family support, who constitutes family? How would you define family? Who is a family member? Because there is no equal definition in all member states of the Council of Europe. In some countries, it's mother, father, children, full stop. In some others, like co-mothership in Scandinavian countries, is nothing new. Father plus in Belgium, also nothing new. So you have different forms of family. Or in the Netherlands, you can be living together apart. So being together during the day, but sleep on the other locations. And it's some community, it's a family. But if we look at the European Court of Human Rights decisions, interpreting especially Article 8 of the European Convention of Human Rights, family could be also without a child. Also cohabiting partners, married, not married, doesn't matter. Then single parents. There were some cases on single parents who were also considered as family and protected by Article 8. Not only biological and non-adoptive parents can also be considered in so-called recomposed families. Like you have children from previous marriage, you marry again, and then you have new children and old children, I mean, from previous marriage and new marriage and so on. So it gets complicated, and life is very dynamic. Okay? So those are protected as well. Broader family, like siblings, brothers, sisters, grandparents, grandchildren, they can also be protected by family life. So it's a broad interpretation also by the court. If we speak about social rights and family protection, so what are social rights? Too narrow interpretation would be that it's just social assistance for those who don't have enough means. That would be too narrow. Too broad, on the other hand side, would be that all rights are social rights, because they're not, growing on a tree. It's by the people, for the people. So agreement in the parliaments, however you call it. So everything is social right. That would be too broad, of course. Also too broad, maybe for today's discussion, would be that labor law and social security would be labor or social rights, because if you look at the European Social Charter, you can see employment, labor, and social security rights as social rights. Also depends on the definition in the countries. Like Belgium or France, they would say droit social is labor law and social security law. Other countries, if you say social security law or social law, would be just social security law. But which provisions of social law do protect families? If you look broadly enough, then I would say all provisions cover families one way or another. You can have in pension systems like survivors' pensions for family members, or unemployment, some certain additions if you have small children, or any other basically benefit could cover families as well. There are specific social risks aimed at family, which we will focus on today, which is maternity, paternity. So it used to be at the beginning only maternity. Some older human rights conventions speak only about maternity, but nowadays, we have paternity rights as well, so fathers, and there is an interesting question in some cases whether mother can claim father's benefit and father can claim mother benefits, which is also possible in some cases. And family benefits or family burden. So every expense that is contributing to the family expenses, or every allowance or benefit that is contributing to family expenses, should be covered as a family benefit. And then also caring for sick child and so on. What is interesting, that social risks develop through time. Also, social norms on what is family, who constitutes family, what should be family protection develops through time, also in pensions, in healthcare, and so on. So let me ask you a question. If today we have pensionable age of 65, 67, or from 60 onwards, what do you think the first pensionable age was in 1889 when the first pension insurance was introduced? And let me disclose that the life expectancy was 58 years of age. So what would you say was the pensionable age? 35? 30? How much? 70. Yes, 70. The average time of drawing of a pension was 2 years. And now we have 20 years, right? Because the notion was different. If you could live until 70 while life expectancy was 58, you were disabled. So old age was a presumption of disability. You didn't have to go through the process of establishing disability, you were considered disabled. Is now everybody who is retiring disabled? Of course not. Because at 60 you can still be capable of working. But it's a an argument or an agreement in the society that from certain age on, you don't have to work anymore and you get a pension, right? That's the stage we are in now. And there might be a next stage. Should you receive the pension regardless if you work or not?
Everyone has the right to have a pension.
Even if you work full-time, continue working, you don't need, there is no income replacement or income loss, you still get a pension.
But you have a minimum pension in every country. I mean,
Why minimum? You earned it.
yeah.
No, I'm provoking a bit.
Or to obtain a pension.
Let me ask you differently.
Yeah.
At certain age,
After a certain age, yeah.
regardless what you do. Let me provoke you a bit more. Should,
You have social rights then. You can
yes.
get some social benefits. Or
Pension is a social right, I would say, no? Okay. But should you get health service even if you don't get sick? Or should you get like physiotherapy? Everybody needs a bit of massage or something. Eh? Or should you get some food supplements instead of medicine because you paid for the health insurance, but you did not use it because there was no income loss or there were no increased costs? The basic question, so arguments are different for pensions and other social risks. And the basic argument for social risk is that it should provide protection to the society when income is lost or reduced or costs are increased beyond certain reasonable extent, right? If you receive a pension and you can continue working full-time, 100%, then there is no social risk, right? But that argument is valid for pensions, but not for others. Why? Why shouldn't you get unemployment benefit if you're voluntarily unemployed? It's private law logics in pensions, in healthcare, in unemployment as well, no? Why not? But let's get back to family. And we can discuss other social risks maybe later on. So there is always a historical background. And family solidarity was replaced by social solidarity. So at first you have large rural families. There was no unemployment. They could take care of disabled people and old age people and so on. So now we have more and more social solidarity. And there is always interplay between national and international social security law because defining what is family support is done by national law. And international law is usually following some practices in certain member states to enact that in ILO conventions, for instance, or the Council of Europe instruments. And then influence is reversed back to national law. Now, childhood and motherhood enjoy special protection in many international documents, in the ILO, in the Council of Europe, especially if you look at the European Convention of Human Rights, but even more so if you look at the European Social Charter. Then you have Articles 7, 8, 12, 16 dealing with motherhood, 17 dealing with children. Children should not be working, for instance, too much during the holiday period, and so on. So it's very detailed case law, much more than in the European Convention of Human Rights. And European Court of Human Rights has quite tight hands to decide over very narrow provisions. So first modern social security was in the 19th century. Interestingly enough, the ILO Convention from 1952 defines a standard beneficiary as a man with wife and 2 children. So social security should be enough for one man with 1 wife and 2 children. Okay, so it's presumption of one single breadwinner who is employed from the first day until retirement, usually the same employer, with some family responsibilities. Now, is that still the case? We are moving away from single breadwinner and single female caregiver model because we have 2 employed, 2 part-time employed, self-employed and employed at the same time. So it's getting much more diverse and dynamic, and also family realities are much more dynamic. We have discussed recomposed families, blended families, single-parent families, same-sex families, and so on, which is also taken into account by the court. There were structural shifts in economy, change social work-life balance. We have a special directive in the European Union. And there's certainly, of course, policy preference. You have different kinds of governments in different countries, more left-wing, more right-wing, that influences social security, and also family protection. And in Central and Eastern European countries, you can see some very narrow definitions of family and some extended support for families as well. We will discuss it later on. So, for the European Convention, the European Court of Human Rights, it's interesting because the European Court of Human Rights is a direct court. So individuals have access to the court, and court decides, legally bindingly decides in concrete cases, and also can provide damages, for instance, in certain cases, right? Whereas Court of Justice of the European Union is indirect court. As an individual, you have no access to that court, but you have access via national courts, okay? And the European Committee of Social Rights usually decides in collective matters, not individual matters. We have a lot of collective complaints, and if a member state has ratified a collective complaint procedure, then the reporting procedure is much easier. So because you open yourself to employers' organizations, workers' organizations, non-governmental organizations, and then that is the control over national state law. European Court has broadly construed civil rights because they decide civil and criminal rights. It has a convention interpretation, so it does not relate similarly to civil rights under national law. And they have concluded that social rights might be civil rights as well. Especially in one of the first cases, Zeebrugge, where they said, yeah, it's based on employment contract, so it's civil law contract partially, and social security, social insurance, so, and it was, I think, 5-4 decision, and they managed to include social rights under the European Convention of Human Rights. But there is threefold importance of the European Convention. One is indirect protection with some other rights, then it's a direct protection, Article 8, for instance, and other provisions with social dimension, which we will discuss later on. So there is prohibition of discrimination. Everybody knows it. It's not a self-standing article. You always have to apply it with some other norm as well, with some right. It's prohibited are various forms of discrimination. And interestingly enough, discrimination comes from Latin discriminare. And discriminare just means to distinguish, right? But discrimination has become a negative term, a negative notion. Also in law, we have discrimination law or anti-discrimination law. It's always, if you discriminate, it's always something negative. So you have a reference group and the group who is compared to the reference group, and then you decide whether it's worse off or not. And it's quite interesting because it influences the decision who you take as a reference group. If you take women as a reference group, male, so men could be worse off, right? And it could be discrimination. But if you take men and you have some positive measures for women, then it's no discrimination. So sometimes you have two-way prohibition of discrimination or one-way prohibition of discrimination, right? Like in some countries, ladies can retire still earlier than men. Is that discrimination of men, or is it a positive measure for women? Okay, it depends who you take as a reference group. And I know that many people speak about positive discrimination. I try to avoid that notion because you cannot be positively treated worse. So it's usually positive measure, it's not positive discrimination. And not every distinction is discriminatory. The court always says, is it discrimination, which situations are comparable, and then decides whether that discrimination was reasonable and justifiable and objectively justified or not. And if it's not, then it's discrimination and violation of Article 14. Then you have the right to respect of private and family life, which the court says is least defined and most unruly because it contains many provisions of protection, so not only family life, but also privacy, private life, home, correspondence. And the court is struggling to insert social rights under that provision as well. There are negative and positive obligations that the court can establish by the states, and for Article 8, the court never says it's a positive obligation that the country should have social security, should provide family protection. But if the country does so, it should be in a non-discriminatory way. So usually Article 8 is applied together with Article 14. Okay? Whereas if you look at the European Social Charter, the state has to provide family protection. Okay? Now, protection of property. That is an interesting article. Property protection was not inserted in the initial wording of the European Convention of Human Rights because there was a misunderstanding, or there was no common grounds between East and West, North and South of Europe. And let me ask you a question. What do you say, is the protection of property a civil right or a social right? Who is for civil right? Who is for social right? I'm on both sides.
I think it's more civil rights because it's your own property, private property. It's not something which is part of in communist system that we
No, okay. Anybody else who said it's a social right? Because it was 50-50.
When I think about it, I would say that it has both the elements of civil and social, but according to my opinion, what prevails is the social one. Because when we talk also about the French Revolution, the period in the 19th century, the right to property was not available to everyone, and it was very unequal, in the sense that in the middle of the 19th century, 2% of the richest
men,
citizens,
usually,
they possessed more than 80%
yes.
of the property. So I would say that in that case, the right to have a property that applies to everyone, that it has a very strong social dimension, that it is not something that is taken for granted.
No, I enjoy the discussion. I love asking you questions.
Same situations also nowadays, especially for rich people.
Okay.
If you want to compare how it was in the middle of 19th century and today, the situation is getting worse, but the level is not as in that period.
Sure.
If you follow these charts, like you can see that these percentages are raising, but it's not at the level of that period.
Yeah, but we are living capitalism now.
Capital. You have it in the treaty on the European Union and the functioning of the European Union. It's not just a market economy; it's social market economy. Yeah? It's different because social is not a correction of market economy. Social in Europe is part of market economy, and that's why we're doing better than US, for instance, in the times of crisis. Because we have safety nets for many people, and they don't. Okay, but let me go back to private property. The scope of defining the right includes the limitations of the right. And the limitations of the right to property are of a social, economic, and ecological nature. That's why in some constitutions, from the countries represented here, the right to private property is the first one among the civil, economic, and cultural rights. Looking at Macedonia, Article 30 of the Constitution, the first right under social rights is the right to property. Croatia, Article 48, I think. The first right under social rights is the right to property. Poland, I think we have representatives of Poland as well here. Article 64, the first right under social rights is the right to private property. Hungary, Article 13, if I'm not mistaken. I've looked it up this morning. You have the right to private property, but also social limitations of the right to property. Okay? So that's why, because of these social limitations of the right to property, it's not unlimited right to property. You have limitations to the right of property. That's why it was not agreed in the first text of the European Convention of Human Rights what kind of right it is. Because if it is social right, it's not part of the convention, but part of the charter. Okay? But that was solved quite soon because Article 1 of Protocol 1 introduced the right of private property, which is quite important article also for social security rights. You have various aspects. If it's legally enforceable social right, then it enjoys the right to private property. There were many decisions related to pensions, for instance, I'm not going to details, but if you want then in the discussion maybe. And there are also non-contributory rights. So even if you don't pay social security contributions and you have some pecuniary right, it's protected by the right to private property. Because sometimes you have pensions you have to pay contributions for. Sometimes you have pensions who are national pensions, so paid out of the budget, so non-contributory benefits. The court in one case, but one case only so far, has gone that far and said even social assistance rights are protected by private property. Squapoire, a Senegalese person, right? And it applied a lot of times, so Article 1P1 in conjunction with Article 14. Now, going to the jurisprudence, and some social rights concerning family support. The first one, the oldest one, I would say, is Petrovic versus Austria. It was an Austrian case. And parental leave was granted to mothers only. And the court applied Article 8 in conjunction with Article 14, so non-discrimination. And the first time it said you should not only respect family life, but also promote family life, which opened then doors for family protection in later cases. There was distinction based on sex because parental leave was granted to mothers only and not to fathers. That was not disputable, it was clear. The question was, does such provision pursue a legitimate aim? And the court said, it does, but you also have a large margin of appreciation in social rights. So, is it against the convention for only mothers to have access to parental benefit? And the court in that case said no, because of the traditional roles of the family. At that time, not many member states knew equal parental rights, like maternity and paternity benefits. So at that time, it was not a violation of the convention, but there were certain, I think 2 judges were issuing dissenting opinions, saying there were no justifiable reasons or no weighty reasons for that distinction. And as I already mentioned, states are not obliged by the convention to provide family support, but if they do, they have to do it in a non-discriminatory way. Okay? But European Social Charter, on the other hand, obliges member states to provide family benefits. Then it was a case, Konstantin Markin versus Russia. The Russian status in Council of Europe is quite clear, I would say. They were ejected from the Council of Europe. They wanted to leave, but then they were ejected before that, I think in 22, right, in February or something, or later on. So they're no longer members of the Council of Europe. But there was a case when parental leave was limited for military servicemen, so for soldiers, and not limited for female soldiers. So female soldiers could have benefit for 3 years, male soldiers could have it only for 3 months. Okay? Legal basis was Article 8 and 14. Similar arguments as in Petrovic. But the difference was that the court said, yeah, but societal norms had significantly changed from that time, so 1908 to 2012, and found that there are no longer traditional gender roles. Many member states have introduced by now already the maternity and paternity benefits. And although certain restrictions are admissible, it should not be discriminatory, and then it found violation because there was no justification for such differential treatment. Because the country didn't say, yeah, men should be always prepared, or this person was in permanent readiness to go to the field immediately, or no nature of the work. It was just discrimination between male and female, regardless of what they do. If they would say, yeah, but you have to be readily prepared, either man or a woman, then it could be restricted, but not. So it was a violation. So then it was Niedzhevsky versus Germany. There was periods of residence. First it was registered residence, then it was limited residence, and then unlimited residence, and they asked for family benefit while they had limited residence permit, not unlimited. Once you have unlimited, so permanent residence, you should have all the rights, but not before. And
in your opinion, do you think that this is also some kind of discrimination?
which one?
You have permit, you should have every possible right from the country, but if you have a limited permit, you are not able to...
Why do you think it's a discrimination?
I think it is.
Why?
Because everyone pays like taxes in that country.
Okay.
Everyone who is paying taxes for a certain country should enjoy the same...
But not everything is paid out of taxes. You have social security contributions as well, and that you might pay in another country. But I partially agree with you, because in European Union, you have two groups of people. One are workers. If you're a worker in European Union, you have the best protection. You can go to another country and say civus europaeum sum, like civus romanum sum in Roman law, and you have all the benefits. And because we have a regulation 492/2011 on freedom of movement of workers. So if you're a worker, you should have all the benefits immediately, even social assistance, because you pay contributions, okay, and taxes. But if you're non-active, then you need some other criterion to be included in the society, because you're not included by work. And that is residence. And it's not enough that you just register residence, because everybody can register residence immediately, but you have to register it after 3 months, right? Free Movement Directive, 2008-34. But then once you have permanent residence, so after 5 years, then you're considered to be included in the life of the society, of this new society, and then you should have all the rights. So that is the distinction between workers, or also economically active people, like self-employed, and non-active people in European Union law. And I don't know if that is really a discrimination. It compares who you compare with.
I'm talking now about Switzerland, since they have that double or trouble rule for the unlimited residence permit and work permit for...
Yeah, Switzerland again.
Unlimited residence permit.
Yeah.
They have social benefits, but for people who work there, and they are also paying taxes and everything, they don't have.
Yeah.
Because they have only limited permit residence.
Yeah. But by the way,
for me, in my opinion, that's discrimination.
by the way, Switzerland is not a member of the European Union.
But it's a member of the CO. I mean, it's a member
Of the Council of Europe, but has not ratified the European Social Charter.
I mean,
A European Convention of Human Rights, yes, but not the Social Charter. Yeah, you're right in a certain extent. It's also, you have also in European Union law abundance of judgments on residence. Because there were people who wanted to have 2 residences, which is not possible. You only have 1 permanent residence. And you have many benefits that are linked to residence, not just to the place of work. Right? Like many family benefits are linked to residence, not to work. We might come later again to European Union law, if we have some time left. So that was a case of limited residence permit, and they were denied family benefits in that period, but they got family benefits after they had unlimited residence permit, and they wanted to have it also in the meantime. And there was a quite interesting case, because in this case, the court retreated basically from the broad interpretation of promoting families just to respecting families, okay? And they said, oh, sorry. And they said, in this case, I think it was discrimination, and there were dissenting opinions because they were not denied family benefits. They just had to be compared to others, families who were residing in that country, okay? So I think they found a violation in that case as well. Then it was X versus others. There were 2 mothers, I think it was Ireland. They had a family benefit. Oh, they were delayed, wait. Yeah, that was in between, and then they was delayed. Where they applied Article 1P1, one of the first cases, but there was no violation in this case. In the Polish case, it was violation. In this case, it was no violation, because they looked at the situation to its totality, they said. And then it was one specific case, Zibek versus Greece, when it was against Muslim Greeks, I think, and they said it was discrimination not just on sex, but also on national origin. It was about family supplement for large families in that case. Now, some more cases in Central and European countries. There was a Hungarian case, quite interesting, because there was a Hungarian father and Romanian mother. They had two children who had Hungarian nationality according to their father, and they were denied maternity benefit, and not the mother, but the father claimed maternity benefit, which was quite interesting, right? And the court says, the question is, what is the aim of the benefit? Is it to contribute to family expenses, or is it to protect mothers immediately after birth? Because they have to recover, right? And there was no limitation based on sex for guardianship benefits and adoptive parents' benefits. It was just for biological parents, I think, right? And they said, yes, it is a discrimination of a father. So father could claim maternity benefit. And they also further said, if children would be claimants and the situation would be reversed, so the mother would be Hungarian and the father would be Romanian, they would be entitled to benefits. So it's discrimination. Which is strange in a way. And some judges said in concurring opinion that wouldn't it be easier for a mother to claim a benefit, it's maternity benefit, and it should be discrimination based on nationality, right? Which is also prohibited. But no, in this case, father was claiming. Then it was a Croatian case where it was a self-employed mother, a businesswoman, who adopted a 3-year-old child and denied maternity leave and maternity benefit. And the Croatian authorities applied maternity leave according to a special law on maternity leave, where you can get only maternity leave and benefit up to the 1 year of age of a child. But the mother was claiming, yes, but according to the Labor Code or Labor Relations Act, you can, as an adoptive mother, you can have 270 days until the 12th year of the childbirth. And Croatia then saw a bit of the mistake, offered some compensation, 4,000 euros or something like that, but the mother denied and then went to the court, and the court said, correctly so, it was a very strict interpretation of Croatian law, it was excessively formal and inflexible, and find a violation, and the mother got much more than 4,000 euro at the end. Then it was Jochova and Ganeva versus Bulgaria. It was also an interesting case. There was a mother, a single parent, and the conditions were that you only get, as a single parent, family benefit if the other parent is deceased, so dead. You should provide that other parent, was a father, and that he died. Otherwise, you don't get single parent benefits, okay? And she argued, yeah, but single parent you can be with even if the father is unknown, or nobody knows who is the father of the child, right? Sometimes in family law, they taught us you could have an exceptio plurium concubentium, so you slept with many men and you don't know who the father is, okay? So in this sense, it was a violation, of course, and it was difference based on sex and family status, so violation was found. And the country said, yeah, we will have excessive costs if you decide like that, because we will have to grant everybody now that benefit for lone parents. And they said, yeah, excessive cost argument can never be a legal argument. So if you have the rule, you have to apply it for everybody, or you change the rule, right? It's always possible. Another one, and I think this is the last one, there was early retirement due to children who need health care. And at first the pension was granted, but then it was ex ofo reviewed and denied. And some other benefit of early retirement was offered, which was far lower than this early retirement pension. Article that was applied in this case was solely 1P1, so private property. She applied in good faith, she received it in good faith. And they said she should be granted that benefit because otherwise it would be disproportionate and excessively burdensome. It was quite an interesting decision, because if the mistake was made, it should be possible to correct it for ex nunc, from now onwards, right? It's not retroactive, it's retrospective effect, so from now onwards. I'm quite good in time, so we can have some more discussion. Because that would conclude my presentation of the book chapter, but I would like to say something about also families in the European Union and European Union law, which was rightfully so mentioned as well. In European Union, and especially is important for students, because if you go to studies to another country, what is your main concern relating to social security? Not the exams, that would be your main concern, I said. Depends where you're coming from, but okay. Health insurance and family benefits, right? I hope you have.
But you always can pay by yourself.
Oh, if you don't know, you always pay. That's always an option, but it's no social security. Okay? You don't have to pay always, right?
Basically, one question. How
Yes.
do you see the future based on the circumstances in the last, let's say, 40 years, and based on the whole situation in society, migration, overaging? How do you see the future?
The future is bright.
The future is
Bright. I'm an optimist, huh?
you're optimist.
Yeah, but now I'm jumping to the conclusions. Let me say something first about coordination.
I know that if we
No, why should we be pessimistic? I mean, we will manage one way or the other, right? So yeah, you're right. Healthcare would be your main priority. And I hope if you're from European Union, you have your European health insurance card, which you can use, okay? And some countries for students require that European health insurance card is enough. Some countries require private insurance, that you have it additional to that. Like in Spain, you need to have private insurance as well. And the other thing is family benefits. If you have family benefits, in some countries it's still possible to get them during your studies. It does not end with 18 years of age, right? If you have it through your studies, then it's the question whether you can retain it as a student if you study in another country. Because initially Social Security was limited to the sovereignty, to the country which provided the benefits, and were not paid outside of the borders. That's an outdated concept, of course. So back to family benefits in the European Union. The rule is that the family benefits should be provided to a worker. Again, a worker status is the best in European Union, as if the family would be residing with that worker. Okay? So a worker or a pensioner, they have priority. And there was an interesting Austrian case, which you might be familiar with, because Austria said, we will index family benefits, which means we will take into account the costs of living in the country where children reside. Okay? If they reside in a lower cost country than Austria, we will pay lower family benefits. And if they reside in a higher cost country, we will pay higher family benefits. It's non-discriminatory in law, de jure. But de facto, of course, it was discriminatory. Who works in Austria? A lot of Danes and Finns and you know, or Hungarians, Czechs, Slovaks, Slovenians, Croatians, right? So lower income countries. Okay, so they saved like 100 million euro each year, right? And the question was, should they treat basically children alike, because children are treated alike in the country where they live, or should workers be treated similarly or equally? And it was clear, there were cases before, French cases of PINA cases, and the court said, yeah, it's discrimination of workers. If you're a worker, you should be treated the same as national workers if the families reside with them. So it annulled or said that Austrian legislation is against EU law, and Austria had to, it was 22, I think it was, the judgment came out, that Austria has to change their legislation and treat all the workers in Austria equally as if the family would be residing with them. But that principle of equal treatment is not absolute, because we have rules who prevent overlapping of benefits. Imagine that the father is working in Austria and mother is working in Hungary. Okay? Then Hungary would have priority, but Austria would have to pay the additional amount, so which is more than Hungarian. Basic principle with family benefits in the European Union is that the family should always receive the highest amount. The question is just how you divide the costs between the countries who are responsible. Okay? But for instance, if my father would be working in Austria and mother would be living with children in Hungary without working, so work would have priority. So Austria would have to pay first, and Hungary, if the benefit would be higher, I don't think it is, but if it would be higher, then the difference would have to be paid. So there are some rules against overlapping of benefits. Now the interesting question is, which country is responsible for your family benefits? And that the taxes argument comes into play, especially with Hudzinski and Wawrzyniak case, because we have a rule that if you work in the country within the European Union, regardless of nationality, that country is responsible for your social security, because that country collects contributions and has to provide all the benefits, right? But there was an interesting case of Bosman. Have you heard of the Bosman case? It's not that one, because it was a football player Bosman. Now this is Lady Bosman, right? So it's 2N at the end. So it was Brigitte Bosman. She was a Belgian national living in Germany with two kids who were studying in Germany, and they had family benefits. But then she found a job in the Netherlands. And the Netherlands became responsible for her social security. And the Netherlands said, yeah, we're responsible, but we don't have family benefits for studying children. We only provide scholarships for students who study in the Netherlands. So they were left without family benefits. And in Bosman case, it's so important because it breaks a bit the rules of social security coordination. The court said, yeah, but if there is a benefit based solely on residence, in this case in Germany, the country should not be prevented to apply solely the national legislation. Should not be prevented means Germany has to pay, because they did not want to pay, right? Otherwise there would be no case. So now we have a rule that you have one responsible member state, but if that does not provide family benefits, the member state of residence can, for residence-based benefits, not contribution-based, can still be called up to pay the benefits, which is quite an important ruling. And Jan Hudzinski and Wawrzyniak, they had benefits in Poland, but they were lower. They were paying taxes in Germany, from which family benefits were financed, and the court said, yes, they should have the full family benefits. Okay, now with family benefits are very interesting because you have a lot of family benefits. In some countries you have, for the first day your child goes back to school, you get some benefit in France. France has especially large spectrum of family benefits. And some benefits are meant for fathers or mothers, some are meant for family as such as a whole. And the court distinguished between those benefits, which is again to the benefit of the families. Because if all the benefits would be in one basket, then overlapping or prevention of overlapping rules apply. If they're in two baskets, there is no overlapping. So family, according to that decision, gets more. It was a Luxembourgese German case of Wiering. We can discuss it later on. Now, who is a family member? There were a lot of Luxembourgese cases because, as you know, in Luxembourg, many people work but don't live in Luxembourg because it's expensive. I mean, the salaries are high, but also the costs are high. Okay, so many people live in Germany, like Trier, or Belgium, or France, and they commute to Luxembourg, right? And they have families. There were cases of non-biological fathers working in the recomposed family, working in Luxembourg. Should Luxembourg provide benefits or not? Luxembourg is always a bit restricting family benefits, and they want to focus on children, but the court said, no, you should focus on workers, and they should have the same benefits as people in Luxembourg, right? If you're married or divorced, doesn't matter. There was a case of, in our language, slanina means, bacon. But it's an interesting case of divorced parents. Mother was Greek, father was in Austria. They divorced, mother took the child with her back to Greece, and father did not want to claim family benefits in Austria, although he was entitled. Because if you break the ties with a spouse, you can't break the ties with a child. But sometimes children suffer because of divorce, of course. But so the father did not want to claim, although he was entitled. Now the question was, could the mother, who was not entitled, claim instead of the father? And the court said, yes. I mean, and it was confirmed in Trapkowski case, because in family benefits you have entitling person, entitled person, and rightful claimant. Entitling person, so the person who opens entitlement is a child. Then you have entitled person, maybe one of the parents, right? And then you have rightful claimant, who can be the third person or the other parent. And the court said, yeah, it doesn't matter who claims the benefits, because it's a family benefit. The family should not be deprived. And Finland, if I know correctly, is now in the process of changing national legislation to open claims also for others. Not only in cross-border cases, but also purely Finnish cases. Because otherwise you come to the so-called reverse discrimination. Reverse discrimination in European Union law is, if you move to other country, you have benefits and more benefits, right? But if you're limited to the legal position or legal situation of only one country, you're in a worse position than compared to the person who moves. So from the aspect of European Union law, it's fine. People who are moving should not be treated worse, they can be treated better. But reverse discrimination is that the people who are not moving are treating worse than those who are moving. And Finland wants to, not just enable, according to the practice of the court, other claimants from other countries, but also other claimants within the country. So that's one of the consequences, okay. And that brings me to conclusions, and we still have plenty of time for discussion. Or we finish earlier, which is also fine. So, yesterday there was a discussion of vertical and horizontal application of human rights, and the state is responsible for human rights. But what if the state breaches human rights? Who controls the controllers? Qui custodiet custodes, right? Sorry? Which bodies? Which bodies in the international communities? Sure, I mean, we have European Union and we have the Council of Europe in Europe, right? I would focus on the...
For instance.
Yeah, if European Union is economic community, it has not so much dealings with human rights as such. It's more Council of Europe, I would say. Because in the Council of Europe is based on three principles, as you know. It's democracy, the rule of law, and human rights, right? And some say it's a tripod, three-legged stool, where you have to respect all of them, because otherwise it cannot stand. Like if you have democracy but no human rights and no rule of law, it's not good. If you have human rights but no rule of law and democracy, it's also not right. If you have human rights, and so all three have to be there, right? But who controls the state? And international community is the correct answer. I would say in Europe especially it would be the European Court of Human Rights, but only according to civil and political and partially social rights. But then you also have the European Committee of Social Rights, who controls European Social Charter. And if you really mean about the indivisibility of human rights, then all human rights should be protected equally, right? European Convention is, they call it a living instrument, which means that you don't apply the static interpretation, but you apply dynamic interpretation. So not what the legislator meant in 1950s, but what a legislator would mean today, right? And it's not an easy task for the court to fight outdated social patterns, because they don't have the instrument. The European Convention is not the best instrument to protect social rights. And we need European Social Charter, and I'm a little bit biased towards European Social Charter, as you can see, but I truly believe that it should be a condition for membership, because all rights should belong to all humans. There is a lot in international law, international communities, but more is required, I would say, within the Council of Europe and within the European Union. So there is always room for improvement. Okay, thank you. And now we have 36 minutes for discussion. Yes?
I can say, maybe I would like to be longer, because there is a reason why I asked the question.
Yes.
I would like maybe the answer to be sincere.
Yes.
Yeah.
I'm always sincere.
I liked, when you started your presentation, that you put family care. Really in the period before the introduction of social security system, let's say the family really provided assistance. Not only the family, it was among the tasks of the church, in the society, also in the feudal order. There were these in some territory feudal lords. It was not a rarity that a feudal lord helped to the people who were living in that area. And why I ask this question about the future of the social security, what comes to my mind is that based on this church, feudal lords, family, that it did not always exist as kind of social security. And there is a specific reason why it appeared in that period of history based on, I would say, two main circumstances. And I think that what am I going to say that it's not possible to deny. And
it's possible to debate it.
both circumstances are very big to do. First, when we talk about Bismarck and the German system, it was a huge influence of social democracy of that period, of the party of Bebel, of Kautsky, that because of that danger, because of that influence, Bismarck decided or was forced to introduce the social security. Similar was later in Europe, because we know that the liberal type of capitalism, when it changed, when it evolved after the world economic crisis, it became social democratic capitalism. And that was the period where this type of social rights, social security, when it flourished in the Western Europe until 80s, let's say. And that was also the period of the huge influence of the socialist parties and communist parties also, whether from the Soviet Union as that kind of danger to the whole system, or whether to that type of parties inside of the Western European state. That circumstance changed in the last period. These parties are not the same anymore as in that, as 100 or 80 years ago. And that's the first circumstance. Other social security, when it was introduced, it was mainly based on the solidarity within a homogeneous national community. Whether it is in Germany, in the Bismarck period,
Still is,
whether it was in Sweden.
Still is.
Still is. But what is the difference is that in that period there was no migration. Okay, maybe it is wrong to say that there was no migration.
He should finish, huh? Don't give him a mic.
Maybe it's a mistake to say that in that period there was some migration, but it is not comparable today, when you can see that the number of migrants is rising. For example, what I follow in Portugal, that in the last 10 and 15 years, the number of migrants got much more than doubled. And whether these two circumstances, bigger migration and the smaller power of social democracy, can have some influence in the future. Or maybe to mention the quality of service that is provided by the state. Because if it did not always exist, maybe in the future it can be abolished. And now when I think about it,
I don't want to go back to the 16th century, thank you.
I mean, like, it's, there is a reason why the private service appeared, and why it is.
Why?
It got stronger.
Why?
But because
Why?
people are generally, they were not satisfied enough with the kind of service that is provided by the state.
That's African argument. They always fear bad governance, and that's why they don't trust public institutions. I don't think that's a valid argument in Europe.
But I think that it is like, I think the opposite, that it is really the European argument.
I don't think
because
so. Because
I'm thinking more about Italy, about France. Okay, maybe I was talking too long, but this is really the topic that I like to read and to think and to contemplate, and I would really like, to.
That's perfect. I hope I can convert you to social security lawyer. So yeah, I mentioned, family support, and then it was changed or substituted to a certain extent with social solidarity, so family solidarity and social solidarity. Why? Because in the past you had large families. Also in the past, when you had movements, you had like Gastarbeiter program, or Italians going to mines to Belgium for a long period of time, taking their families, or it was a long-term movement. It was predictable. Nowadays, we have a lot of short-term movements. I'm here for 2-3 days, I move to another country, and it's unpredictable. And families, you don't live together anymore. You're here, your family is, I don't know where, huh? So, I mean, in other countries. So, family support cannot provide the protection anymore. That is why we need social solidarity. But now, according to the Universal Declaration of Human Rights, everyone, as a member of society, should have the right to social security. Okay, so it's based on individual and natural law rights. It's a fruit of 20th century on the tree of 19th century in a way. But now who is everybody and what is society? And according to the interpretations of the International Covenant of Economic, Social and Cultural Rights, everyone means everyone in a sense, old, young, male, female, healthy, non-healthy, young, old, so everybody. Migrant even is everybody of the society, right? But then we have the discussion who is migrant member of the society or not. And the other question is, what is society? Is it still national? Can we still focus only on national social security? Or is society more than national society? Because if you're national of the European Union, you have two nationalities, right? We used to have in Yugoslavia two nationalities sometimes, some time ago. Huh? But now we have it again. You have Hungarian nationality and European nationality, so you have two nationalities. And it comes handy. If you're in Africa and you don't have representation, you can go to any consular diplomatic establishment and they will help you, right? So it has some benefits to it. Are we yet there to say we need European social security? And that is a problem. A problem of a mindset and a problem of over-politicizing social security, I would say. Because every country is very sensitive about their social security. It's a lot of money. It's second and third budget in the country, usually. Pensions and healthcare, right? There were attempts to establish European unemployment benefit scheme. Okay? But it failed. There was an initiative to have, when we had 12 member states of the European Union, to have a 13th state social security. Now we would say 28 state social security, because we have 27 member states and one European Union, which should be the 28th state. But the countries, even if they have to cooperate sincerely and mutually trust each other, they don't. If you look at the social security coordination regulation, so protecting migrants' persons' rights within the European Union, there is a proposal of the Commission from December 2016. Now we're approaching December 2026, and that proposal has not been adopted yet. Also, if you look at postings, okay, posting of workers to another country. Some countries do it as a business model. They just issue A1 forms for postings, regardless everything, not respecting the rules. And other countries are very much strong on social fraud and discovering, like Belgium and so on. But I will not go into details. So my point is, we are not, I will not use legal terms, mature enough yet to have a European or federal, in a way, social security system. Would we need it? Maybe. I don't know. Otherwise, we could have more enhanced and sincere cooperation between national social security schemes. That's the first thing. The second thing, the future of social security. Of course, it's bright, right? You mentioned Bismarck. Bismarck established social security not because he wanted to do something for the rebellion workers, to social movement in Germany, led by professors, by the way, but he wanted to stay in power, right? He was a politician, typically. Yeah. Okay. So he established social security in a way that workers and employers would pay and administer, and the state would only supervise. So that's one of the first or modern social insurance-based schemes, and Beveridge later on was national protection, right, schemes based on residence. I will tell you an anecdote. I was invited to speak about the future of Max Planck Institute for Social Law, Social Security Law. And there was also a professor saying, will we have money for social security? We have to spend on defense. It's a wrong question. Because not just in every society in a peaceful era, especially where there are disruptions, be it economic crisis, be it sanitary crisis, be it military crisis, you need more solidarity in society and not less. Right? And there is a concept of the ILO saying you have to find budgetary space or fiscal space for Social Security because you need it. Okay, you cannot say, as Margaret Thatcher, there is no such thing as society, everybody is individual, because, you know, you need roads, you need schools, you need a lot of things that are common to everybody. Okay. So my answer would be, of course, we will need more Social Security. The question is how it will be shaped in each of the countries. In every country, or in more countries, we just had elections in Slovenia. The first parliament was now in session yesterday. You have elections in Hungary, you have elections all over, right? So it is, and we have, like in the history, I didn't go into basics, but in the history, you always need structural elements, cultural elements, and political preferences. So structural elements were new forms of work, like workers were dissatisfied, they were working long hours, no protection, and so on. It's the same now. Platform workers, are they protected or not? We have new forms of organizing work. It's not just everything is labor relations, right? That we have new structures. We have new structures of living. Can we afford housing? It's a big issue in some countries. Okay, that's structural elements. And another is cultural elements. You need legitimacy. You need upheaval from the people. You have to request it. Now, social rights and labor rights were never gained under the green table or by the green table. It was always on the streets. So you have, like in France, you always have revolution on the street when they want to raise pensionable age from 60 to 62, which is for others quite normal, right? Or healthcare. So you need structural elements, you need cultural elements, and then you need policy preferences, because you can have more left-wing, right-wing, whatever kind of governments, and they all influence shaping of Social Security. So my reply to your question would be, yes, we need Social Security. Yes, we need more Social Security. How it will look like, it depends. Thank you. We still have some minutes, so or we finish. I'm looking at the big boss. He's not looking at me. We finish? Okay, thank you very much. You have a question? Okay. Okay, a small question, a long answer.
Yes. What do you think the single person is the member of the family?
Single person, one person.
Not single parent, single person, yes.
Single person is a family. No, I mean, why?
That's why I'm asking.
But why? Why would you?
Because in Family Code of Ukraine, it is the member of the family, single person.
Of which family?
Family, that's
One
you are
person
living
family.
alone, yes. This is the
Me,
so
I,
in
and
Ukraine
myself.
they are thinking that the single person is the family, but because you are going shopping, you're cooking, you make these social things. And that's why I'm asking, what do you think about it?
I'm sorry we didn't finish earlier. No, it's okay. Well, the question of every status, like if you're disabled or unemployed, or if you have a status of a family, is why and what is the consequence, right? Do you have some benefits to have a status of a family? My opinion would be that you have living communities and families usually suppose a child, because families enjoy protection because of children. You're classified as a family usually because children have special protection, and maternity and paternity and so on, right? To have a single person described as a family, the question would be why? What do you gain by it? Do you get, I don't know, what do you...
But they live the same life like families with children, without children, parents, single parents. So this is the philosophy of this family code.
Yeah.
Well,
If you get...
That's why I asked, what do you think about it? Thank you. No, it's
I don't have a clue. No, but yeah, but I mean, if you know why you have to define it as a family, maybe to get family support, but you have other kinds of support to single persons, right? I don't think you necessarily need to be a family to have some social support in that sense. But if you do, then it's fine. Okay. You need Social Security, but how you need it and what, that is an example. Okay. Okay, thank you.
Okay.